I'm Ben Meiselas from the MeidasTouch Network. Oral argument was held before the 11th Circuit Court of Appeals in connection with the Department of Justice's expedited appeal challenging Judge Aileen Cannon's assertion of equitable jurisdiction, which essentially interfered with the Department of Justice's criminal investigation into Donald Trump after they executed the valid search warrant where a magistrate judge found probable cause, and the search warrant was executed on August 8th. Now, the Department of Justice already received their 100 classified records back that they obtained in connection with the search warrant, which was originally blocked by Judge Aileen Cannon, the federal district court judge in the Southern District of Florida, who perplexingly granted Donald Trump's motion for judicial oversight, and she asserted equitable jurisdiction. The 11th Circuit previously held that Judge Aileen Cannon did not have equitable jurisdiction relating to those 100 classified records, but now this was the expedited appeal regarding the 11,000 other documents that Donald Trump stole that the Department of Justice obtained in connection with the search warrant executed at Mar-A-Lago, in essence removing Judge Aileen Cannon from the case and basically overruling her decision that she should never have asserted jurisdiction in the first place. Now, this went to the 11th Circuit Court of Appeals, and as I explained before in these videos, I was 99% sure the 11th Circuit Court of Appeals was going to rule in favor of the Department of Justice and rule that Judge Cannon should have never asserted jurisdiction in the first place and stop the whole special master process. Now, after listening to oral arguments in the 11th Circuit, which took place on November 22nd in the afternoon, I am 100% confident that Donald Trump is going to lose this case and that the Department of Justice is going to prevail. It's just a matter of when the 11th Circuit is going to issue their order. Now, the 11th Circuit did not announce at oral argument specifically that the Department of Justice would win. However, in the questioning, which I am going to play on this video for you, I'm going to show you clips from the oral argument. The 11th Circuit Court of Appeals asked the Department of Justice how they should word their order, showing that the Department of Justice won and reversing the decision by Judge Aileen Cannon. So first, let's talk about the players in today's oral argument. So the court is a 3-justice panel. It is a different panel that previously ruled in favor of the Department of Justice returning those 100 classified records, but 2 of the judges were the same. Judge Britt Grant, who was a Trump appointee, who ruled against Trump in the previous 11th Circuit appeal, and Andrew Brasher, another Trump appointee. He's on the panel. He also, though, ruled against Trump in the previous appeal the Department of Justice filed returning the 100 classified records. And the third judge, Judge William Pryor, who's the chief judge of the 11th Circuit, is a George W. Bush appointee. He was not on the original panel, but 3 Republicans on this panel. But going into oral argument, it was good news for the Department of Justice because 2 of the justices were the same justices who already ruled in favor of the Department of Justice. Now, who was arguing for the Department of Justice? The assistant to the Solicitor General, somebody by the name of Sopan Joshi, was arguing for the Department of Justice. That's what the job of the Solicitor General is. The position is usually arguing in front of the Supreme Court. And their top deputies, in this case, assistant to the Solicitor General, Sopan Joshi, makes the arguments oftentimes to the circuit courts of appeal, in this case, the 11th Circuit Court of Appeal. Sopan Joshi did an incredible job. I'll play for you some of the back and forth with the court. And arguing for Donald Trump was Jim Trusty. Donald Trump doesn't have any of the Alina Habas or people like that make the argument. Look, Trusty has always been pushing forward these very disingenuous arguments, but you'll see he does it in an eloquent way. But when you go in front of 3 very intelligent judges, they're able to call it out right away. And the bench was very hot. And the bench right away basically called out Trump's lawyers for not having any single precedent that they could point to, not a single case anywhere in United States history where a judge did what Judge Aileen Cannon did. And what the court consistently said during oral argument today is pre-indictment. So Donald Trump's being criminally investigated. Is there any case out there that you are aware of where a court has asserted equitable jurisdiction to stop or interfere with the Department of Justice's criminal investigation, where an injunction issued, where there's not been a finding that the Department of Justice engaged in unlawful conduct, yet alone the even higher threshold for equitable jurisdiction, which is a callous disregard for the rights of the person being investigated? And both the Department of Justice and Trump's lawyers said there's not a single precedent, not a single case out there for what Judge Aileen Cannon did. Now, I'm going to play you the clips from oral argument and what actually took place in court, because there was an audio recording, not video, but there was an audio recording only of oral argument. But the key point I want you to think about, what everybody's talking about here, just so I could frame these issues. And by the way, I'm not going to play for you the full oral argument. I went through this and clipped for you the key moments of what transpired at the hearing. But the key thing for you to know is that in order for a district court judge to basically meddle with the separation of powers, where it's the executive branch's role through the Department of Justice to engage in those criminal investigations, they find that there's a probable cause. A magistrate judge finds probable cause. The Department of Justice executes a search warrant, and they pursue their criminal investigation. They either file criminal charges or they don't. But for a federal court to interfere with the executive branch's criminal investigation, you have to find the most extraordinary circumstances, because judges, the federal judiciary, is not supposed to interfere with the executive branch, and the separation of powers are supposed to hold. So only if there is a callous disregard of the rights of Trump or whoever is being investigated, only if that threshold is met, can someone like Judge Aileen Cannon intervene. And that has not occurred here. And it hasn't occurred here because a magistrate judge found probable cause. An affidavit was submitted to a magistrate judge that Donald Trump was stealing top secret classified records. And Donald Trump was caught stealing those records. There's not even an accusation here, and this is what the judges continued to point to, and you'll hear it in the oral argument, setting aside the callous disregard, which is even a higher standard than just the underlying conduct being unlawful. There is no finding that the Department of Justice engaged in even unlawful conduct with respect to their search warrant that was executed at Mar-A-Lago. And so the court presses Trump's lawyers and says, hey, look, can you point to a single case here? So let's start off and let's play you some of these video clips. Let's begin with Judge William Pryor speaking to Sopan Joshi, the assistant to the Solicitor General, and basically asking the lawyer who represents the Department of Justice, is there any precedent here at all for an assertion by Judge Aileen Cannon of jurisdiction? Play the clip here.
Is there any precedent for exercising equitable jurisdiction in a pre-indictment scenario where there's no showing that the seizure itself was unlawful?
We have been unable to find a case in which that has happened, Your Honor, and I don't think plaintiff has identified one in his briefs either.
And here again, the court asks the same question. The court basically says, look, callous disregard is a higher standard than the Department of Justice simply engaging in unlawful conduct. But here, there is no finding that the Department of Justice engaged in unlawful conduct at all. The Department of Justice executed a valid search warrant. There was a probable cause determination. So is there any precedent that in a situation like this, a judge like Judge Aileen Cannon can intervene? Of course she can. Play the clip.
It seems to me the callous disregard for constitutional rights is a little more of a showing than just that it was an unlawful seizure. I mean, it could be debatable whether the seizure itself was unlawful. A callous disregard for constitutional rights is even a higher burden, I would think. But my question was, has there ever been an exercise of this kind of jurisdiction where there's no showing that the seizure itself was unlawful?
Not to my knowledge, we've been unable to find a case. Plaintiff has not cited a case, and I think that's a pretty good indication that perhaps no such case exists. Nor have we found a case in which this kind of anomalous jurisdiction was exercised where the plaintiff couldn't show a need for the return materials. Here, plaintiff hasn't even attempted to show a need for the return materials, and at all events.
And then as Soap and Joshi's oral argument came to its conclusion, really what the judges were focused on here is asking Assistant Solicitor General Joshi they were asking his advice about what their order should look like, overruling Judge Aileen Cannon. And it gets technical here about whether it should be reversing and remanding to Judge Aileen Cannon with instructions, or whether simply to dismiss and vacate the injunction. And ultimately, I'll combine these two clips together. The Department of Justice lawyer basically says, look, at the end of the day, if we're saying Judge Aileen Cannon was wrong and she's removed from the case, if you want to call it vacate the injunction versus reverse and remand with instructions, it's literally the same thing. What we are saying is Judge Aileen Cannon is wrong, case over, special master process ends. None of this should have taken place in the first place. Judge Aileen Cannon, you were wrong. Return all the documents to the Department of Justice. Here, let's combine these clips and play them right now.
So your brief and your reply brief especially argued that that the proper decretal language would be that we should reverse and remand with instructions to dismiss. It seemed to me that because this is an appeal from an injunction for purposes of appellate jurisdiction, what we would do, if you're right, is we would vacate the injunction, vacate this order on the ground that there is a lack of equitable jurisdiction. But that would be it. What we would have jurisdiction over is not the entire case. We have jurisdiction if we have jurisdiction, right? If we haven't, it's over that order granting an injunction. Isn't that right? Technically, instead of reverse and remand with instructions, it's really just vacate. I mean, and ordinarily, if a district court lacks jurisdiction, that's what we do. We vacate and remand with instructions to dismiss, right?
Fair enough, and I'm not going to fight you too hard on it. If what the language says is vacate and remand with instructions to dismiss the case, I think we would be perfectly happy with that.
And so what you're saying is we, in your view, if we decide that there was not equitable jurisdiction over this claim in the first place, we wouldn't need to go through any of the bases of jurisdiction for the injunction of special master or anything like that. The dismissal of the lack of jurisdiction over the case as it was brought would resolve all the questions in your mind. Is that right?
I think that's right, because plaintiff filed this extraordinary motion to kick off these proceedings. It's not even a complaint. It's just a motion for judicial oversight of an executive branch investigation. And if you find, as we're urging you to, that under binding circuit precedent, it was an abuse of discretion to exercise equitable jurisdiction over that motion, then that would resolve the entire case.
Okay, so next up is Jim Trusty. Here's a photo of Jim Trusty. I want to play for you like the first 4 or 5 minutes of the oral argument here, because it's hard to even clip it because it's just so freaking good. And here you have the judges on the 11th Circuit, the justices, start grilling Jim Trusty right away. So Trump's lawyer, Jim Trusty, what a ridiculous name too. He tries to go up there and tries to do the spin that he does on the right-wing echo chamber, and boom, right away, the judges go in there and basically say, okay, name me one case that says anything that you're talking about. You're just making this up. So please name me one single case that basically says pre-indictment, before Trump is indicted, a judge like Judge Aileen Cannon can assert equitable jurisdiction where there's not a finding that the Department of Justice engaged in unlawful conduct. So I want to play this full 5-minute clip, but a few points I want you to focus on to guide your understanding as I play these clips. Jim Trusty tries to call what the Department of Justice did. He tries to call it a raid, and the court goes in right away, and Justice Britt Grant calls Jim Trusty out right away for that and says, Why are you calling it a raid? It's an execution of a search warrant. And right away, Jim Trusty apologizes. This is why MAGA hates our court systems, because they can't get away with their BS gaslighting that they do on their right-wing media channels. So why the right wing is trying to destroy the court system, because even on the court system where you have justices who ideologically you may have disagreements with, I mean, look, a judge, Justice Britt Grant and Justice Andrew Brashear and Justice William Pryor, I disagree with them probably on a lot of issues, but on issues like this, they are still following the law and challenging stupidity that goes before them. So focus on that, where Jim Trusty apologizes for using the word raid. And then I want you to also just focus on just kind of Jim Trusty here kind of flailing, and then the justices go, what are we doing here? Like, why do you have us here? If ultimately what you're saying is that there is no case precedent at issue, like, what's the point of this? Here, let's play this 5-minute clip. I promise you every minute of this is worth your listen. And then I'll have 1 or 2 more clips to play at the end, which I promise you will want to hear as well. So roll this clip.
Rebuttal, Mr. Trustee.
May it please the court. My name is Jim Trusty. I represent the appellee. Pleasure to meet you. Your Honors, as to the issue of equitable jurisdiction, I think some context is necessary. I think that some actual process here needs to be described, because I don't think that the appellant's briefing has fairly captured the thoughtfulness of the process established by Judge Cannon and where we are.
You heard my question for your adversary. Are you aware, can you cite me a single decision by a federal court other than this one, where a federal court has exercised equitable jurisdiction in a pre-indictment scenario, reviewing a seizure where there's no showing that the seizure itself was unlawful?
Your Honor, not in the context of an immediate, fully formed motion that indicates that, in fact, we know this to be an unconstitutional seizure. I agree with the court's premise that there's not case law. I would start with the broader premise, which is there's also not a situation in the history of this country where a sitting president authorized a raid of a presidential candidate's home. So we have some initial context.
Do you think that raid is the right term for execution of a warrant?
Or execution of a warrant. That's fine, Your Honor. I apologize for using a more loaded term. But what I would suggest is that Judge Cannon looked at the Ritchie factors, and she ruled, obviously, that in 3 cases, and I'm going to come back to the importance of callous disregard in a moment, or exactly where that kind of fits in the scale.
Well, it's the first factor, and she found that it wasn't satisfied, and your brief doesn't even attempt to argue that it was satisfied.
Understood. And what that reflects ultimately, Your Honor, is we're in a position where we're in a process that this judge has created. It is not prejudging that relief will be available in the grand scheme of things under Rule 41G or under the Fourth Amendment. It is an initial moment of use of equitable powers to allow the parties to...
It seems to me the entire premise of the exercise of this extraordinary kind of jurisdiction would be that the seizure itself is unlawful. And if you can't establish that, then what are we doing here?
We are in the process of establishing that, Your Honor. That's exactly what this judge has contemplated, is not immediate protective pleadings where the attorneys file things and say, we think there's a Fourth Amendment violation.
So you're saying that the end object here is to establish that it was an unlawful seizure?
From our perspective, and we have good reason to think that there's now evidence of unlawful seizure, by way of this being a general warrant, by way of this being something that violates the Presidential Record Act, possibly having...
But you didn't establish that it was a general warrant.
But, Your Honor, the point is, how could we establish these things without even having access to the documents at first? We're talking about a moment in time where Judge Cannon acted with limited discretion, with a limited use of, obviously, a limited power, to establish a process where we could fully explore it instead of filing unbased motions claiming constitutional violations.
I've not understood that to be the purpose, even the purpose that you all have articulated. You've asked for a special master to review the documents for privilege. That doesn't sound like an attempt to demonstrate that the seizure was unlawful.
Well, it is a combination, Your Honor. We do not know as we sit here today what presentation was made by the affiant to obtain a warrant. There's still a whole universe of potential Franks-type challenges to the obtaining of this warrant from the magistrate. So we start with, yes, we exercise. There were 2,900 documents that were taken, most of which incredibly personal documents, photographs, thank you notes, birthday cards, golf shirts. We didn't know that at the time that we initially met with Judge Cannon. We knew there were concerns about the overreaching nature of this warrant, of the execution of this warrant, but we still don't know what's in the affidavit. So,
do you think it's rare for the target of a warrant to think that it's overreaching?
I don't think that the target's position was particularly at issue here. It's the attorneys assessing the conduct of the FBI and taking part in this unprecedented search warrant execution. And this
I told you would have wanted to listen to that full clip. I'm glad you listened to each and every moment of that, because you see there, it was really Chief Judge William Pryor and Justice Britt Grant who were grilling Jim Trusty. And Trusty was flailing because his position, as I've always been saying here on the MeidasTouch Network, completely lacks legal merit. And here, I want to show you a clip where we have Justice Britt Grant and then later Chief Justice William Pryor of the 11th Circuit. They both are grilling Jim Trusty on the following question. And they're basically saying, set aside that this involves a former president. Is there any difference at issue here than any other individual who's being investigated for crimes in this country? And what you'll see happens is that Trusty tries to dodge it, and then Chief Judge William Pryor steps in and is like, you're avoiding the question. Like, answer the question. You are not being responsive right now. And it goes to this bigger point here, which I'll talk about after I play the clip.
Faith in the criminal justice system. And that's really
if you set aside, which I understand that you won't want to do, but if you do, for the purposes of this question, set aside the fact that the target of the search warrant was a former president, are there any arguments that would be different than any defendant who, or any target of a warrant who wished to challenge a warrant before an indictment?
Your Honor, what I would say is that we're not looking for special treatment for President Trump. We are recognizing there is a context here where no president has been...
I don't know that that's particularly responsive. The question was, set aside the fact that the subject of the warrant is the president. What's to distinguish this from any other subject of a criminal investigation?
Other subjects of criminal investigations have the exact same Fourth Amendment rights as executed through Rule 41.
Your answer is there is no difference.
Correct.
Yeah, and so the bigger point at issue here is that what Trump's lawyers are advocating for would completely upend our criminal justice system. I mean, and what Judge Aileen Cannon did is a complete perversion of our political justice system for a federal judge to simply intervene and to block the Department of Justice's criminal investigation. Imagine if every person being investigated for crimes rushes to a federal court and federal courts are stopping Department of Justice from engaging in criminal investigation when there's no finding at all that anything was unlawful, yet alone a callous disregard for the rights of the person being investigated. Like, it literally makes no sense at all. I want to turn to, as the arguments kind of reached its conclusion, really where the justices were focused on here, was that, like, Jim Trusty, you're not focusing on really what the issues are. Like, you're just saying a bunch of word salad here. What we have to determine, what we're focused on, is why in the world a federal judge, why did Judge Aileen Cannon get involved in this in the first place? What was the reason that she got involved? She should not have gotten involved unless there are these threshold findings of this extreme and extraordinary misconduct, that it's such a callous disregard for Trump's rights. without her finding that, no judges are allowed to just intervene in Department of Justice's cases. So this is what the kind of oral argument concludes with, the justices really teaching Jim Trusty a lesson in what the law is. Here, play this clip.
This is a judge who's giving us an opportunity. She is initially creating a carve-out of limited equitable jurisdiction for us to explore whether or not there's a valid claim. The case could fizzle out in a couple of different ways. It could fizzle out with the court saying, I've seen your Rule 41 pleading, and I'm no longer exercising equitable jurisdiction because you have no claim. It could fizzle out with attorneys looking at it and saying, we are no different than anybody else in the world, and we can't come up with a basis.
But the problem is we have to determine when it's proper for a district court to do this in the first place, which is what we're looking at now. And the last question was one posed that makes clear that basically, other than the fact that this involves a former president, everything else about this is indistinguishable from any pre-indictment search warrant. And we've got to be concerned about the precedent that we would create that would allow any target of a federal criminal investigation to go into a district court and to have a district court entertain this kind of petition, exercise equitable jurisdiction, and interfere with the executive branch's ongoing investigation.
But, Your Honor, the greater context of this case, and again, it's not special treatment, it's just basic facts of where we are. This is a situation where a political rival has been subjected to a search warrant where thousands of personal materials have been taken. We can't ignore that in the context of equity, which considers certain things, such as the impact on the community when it comes to their view of the criminal justice system. And again, it ignores, I understand as an endpoint it's a concern. We don't want to open up floodgates.
It's not just the endpoint, it's the beginning point. You know, and you've talked about all these other records and property that were seized. The problem is, you know, the search warrant was for classified documents and boxes and other items that are intermingled with that. I don't think it's necessarily the fault of the government if someone has intermingled classified documents in all kinds of other personal property.
Okay, did you like that part at the end, though, where they go, it was Justice William Pryor, who says, it's not the fault of the government when Trump decided that he was going to intermingle his records with top secret classified records. Not the government's fault that Trump mixed magazines and personal things when he stole top secret classified records. Like, seriously, you're going to blame the government for that? And then finally, the justices basically say, look, Jim Trusty, like, what you're trying to argue is that we shouldn't focus on the injunction, but that's the whole case. The heart of this case is the injunction. And while you say it's overblown, this idea of a federal judge interfering with a criminal investigation to help someone who stole top secret records and other government records, that makes no sense. You can't just issue an injunction. Here, play this final clip.
The problem with all of that, though, is that you view the injunction as the most overblown part of this, but think of the extraordinary nature from our perspective of an injunction against the executive branch in a pre-indictment situation. I mean, under the separation of powers, the judiciary doesn't interfere with those kinds of prosecutorial and investigatorial decisions, right?
I understand.
And the whole nature of this kind of jurisdiction is it has to be extraordinary, which is why I was asking, are you aware of any authority where it's ever exercised where there's not at least an initial showing that the seizure itself was unlawful?
And there you have it. So what happens next? So the 11th Circuit Court of Appeals will likely be making a written order very soon. That could happen in a few days. It could happen in a week. It could happen in weeks. But I've always predicted end of November, early December that there would be an order officially overturning Judge Aileen Cannon. The whole special master process that should never have started in the first place is going to come to an end. It's going to be quite humiliating for Judge Aileen Cannon, this order. She should never have asserted jurisdiction in the first place. I mean, going back to what Judge Pryor said earlier, I think about this quote: why are we here? What is going on, basically? Like, this should never have taken place. And so Judge Aileen Cannon's going to be overruled. The government's going to get their thousands of records back. The Raymond Dearie special master thing is going to come to its end. I suspect it'll come to an end before the next hearing before Judge Raymond Dearie. And for all of this, Trump's going to lose. And he didn't really delay anything. In fact, he helped the Department of Justice because all of the arguments that he's made about these records being personal records and executive privilege in many ways make the criminal case against him easier, because Trump's out there now making statements where someone being investigated for crimes in that situation would normally invoke their Fifth Amendment, or their lawyers would tell him, just be quiet. But Trump's made all of these filings now, his lawyers have, asserting that these records are personal records, that Trump took these records and are claiming them as his. I think that will absolutely be helping special counsel Jack Smith in Jack Smith's criminal investigation. And so we will keep you apprised here on the MeidasTouch Network as soon as we hear the order from the 11th Circuit Court of Appeals. But I hope you enjoyed that recap. And most importantly, it was great to actually share the audio of the oral arguments so you could hear the lawyers and the arguments that they're making. After following this channel, after hearing my descriptions of what was going on, for you to actually hear what the lawyers are saying, I think adds an important layer to this all. So I so appreciate you. Hit the subscribe button. We're on our way to 1 million subscribers thanks to your support. And in addition, please consider joining our Patreon, but go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's lots of great exclusive content there, but most importantly, you can help grow this independent media platform. We're not funded by any outside investors at all, so we rely 100% on your generosity. No worries if you can't, but if you can help grow this platform, please consider it at Patreon, patreon.com/MeidasTouch. And while you're here, check out the new true crime podcast that MeidasTouch is the executive producer of. It's called American Psyop, AMERICAN PSYOP, American Psyop. Wherever you get your podcast, search it. It's one of the top true crime podcasts in the country right now, and I know you will love it. American Psyop, brought to you by MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.